During the course of jury selection in a medical malpractice case, one of the jurors asks to speak to us outside and tells us that they have some familiarity with the type of injury of the case that we are bringing now. Does that automatically disqualify that particular juror? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So imagine this scenario. It's a failure to diagnose cancer case, a failure to diagnose breast cancer. And now we're questioning potential jurors. During the course of jury selection, the jurors quickly learn that this is a failure to diagnose breast cancer case. And now one of the jurors raised their hand and said, "Excuse me, Mr. Oginski, I was diagnosed with breast cancer. Can I speak to you outside?" So now I will go outside with the juror, together with the other defense attorneys, and now try and explore what the issue or the concerns are. Typically what they will say is, listen, I went through the same process. I was diagnosed with breast cancer. I understand what happened. I understand what chemotherapy was needed, what radiation treatment is needed, what surgery is needed. I may be the right person for this jury. Or on the other hand, they may turn around and say, you know what? I can relate too much to what your client's going through. I think I'm going to lean in favor of your client. So now, once the juror raises an issue, I now have to ask certain questions. Really, what happened in your case, ma'am? Tell me a little bit more. In your situation, do you feel that a doctor misdiagnosed you? Were you timely diagnosed? Did you have appropriate treatment? Did everything go okay? What was your outcome? And now the defense attorneys will also have an opportunity to question this juror. And now their goal is to find out whether or not that person is going to align themselves more with my client because there's an affinity now. This person had breast cancer and was diagnosed timely. My client was diagnosed with breast cancer, although she's claiming it was not timely diagnosed. Is there going to be that connection? And if the defense thinks there is, they may ask the judge to excuse this juror. It's known as a challenge for cause. The defense attorneys will likely try and get the juror to excuse themselves. Why? Saying that they now have an affinity and they are worried that they are going to bend over backwards to lean in favor of my client. And based upon the responses that this potential juror gives, now we'll have to go to the judge to resolve whether or not they're going to have to use one of their peremptory challenges to excuse this juror, or whether the judge is going to excuse this juror, known as a challenge for cause. So why do I share this great information with you? I share it with you because this does come up every single case. You typically will find somebody in the jury pool in a panel of jurors who says, you know what, I've had a similar experience myself or a family member. And now we have to talk to them outside the presence of the other jurors to find out whose side are they more likely to favor and if they are going to prejudge this case. You know, I realize you're watching this video because you probably have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.